Good morning. Happy Tuesday. I received an email from Earl on Valentine's Day, which, thank you, Earl. He's trying to negotiate with me over the use of the complete and unedited video that he made of himself answering questions to the investigators at Deer Park Police Department. I have not responded to that email, nor do I intend to. Just so everybody's on the same page. I mean, I wouldn't have told Earl specifically that I wouldn't respond to his emails, but he should have watched my previous videos on this subject when I was helping out 10th Man. And he should have recollected my previous pattern of behavior from the last time that we've gone through this. The thing about settlement negotiations is they only work when both sides think they have something to win and both sides think they have something to lose. So that said, it was a real shame that Earl wrote me the email. That does indicate that he does not yet have an attorney. If he had an attorney, his attorney would have written an email. But I'm hoping that he's looking for an attorney. And because hiring an attorney is a very difficult thing to do, especially if you don't know anything about the law. And despite what you may think, unless you're an attorney, you probably don't know a lot about the law. And believe it or not, attorneys hire attorneys. I have represented attorneys. I have seen other attorneys represent attorneys. It is a common thing that if you don't know what you're doing, you hire an attorney. So how do I recommend that you, as a layperson, hire an attorney? Well, you start off at the initial client interview. The initial client interview should be a way for you to get to know a little bit about your attorney's understanding of the facts and the law, and also an opportunity for your attorney to get to know a little bit about you. If your attorney is uninterested in the facts and the law, if they're uninterested in the nuance and the details, if they just want broad overviews, broad strokes, and then they tell you that they could help you, what they are actually saying is they are planning on helping themselves to your wallet. Because you have to remember that initial client interview is the attorney's attempt. They offer you that initial free consultation, but that's really to get you in the door, to get you to sign up. That's the purpose of it for the attorney. But you as the client can change that. You as the client can go in there and demand answers, and if the attorney is not willing to give you specific answers, then obviously you don't need to retain that particular attorney. Now, I'm not suggesting that you go in there and demand answers and then don't retain an attorney who does give you the answers, because if you needed to ask the attorney for answers, your lawsuit probably won't go very well if you don't have an attorney. But that being said, see what the attorney actually has to say. See what the attorney knows about the law. See what the attorney understands your facts to be. If he can actually retain and understand your facts and apply them to the law and give you some indication of how likely or unlikely it is that you're going to succeed on the merits. He's not going to be able to, or he shouldn't be able to, give you you've got a 73.5% chance of prevailing on this, but he should be able to couch it in terms like you're more likely than not going to succeed on this, provided you don't, make any real mistakes in the procedure or in laying out your case. He should be able to give you something along those lines. He should be able to give you a basic understanding of what your damages could be. Now, he can't tell you what a judge or a jury is going to give you as damages, but there there are specifically calculatable damages that you basically start your assumption from. And that specific calculation are your special damages, or your economic damages is what they're called. Depends on the court. Special damages or economic damages. But what those are the things that you have actually, either monies that you haven't made that you can show, like, I wasn't able to work for a month and I make $10,000 a month, and so, I'm out $10,000. That would be an economic damage. Or, my hospital bills were $100,000. Well, that's an economic damage. Your attorney should be able to give you a rough range based on the numbers that you provide him. If it does vary. It does vary from state to state. It does vary from county to county. Some counties give better damages than other counties do, and it just kind of depends on the people in the county, whether they're liberal or conservative. It depends on what their particular outlook on corporations are and things like that, who the plaintiff is, who the defendant is. But you can get rough kind of estimates. Typically, in the county that I normally practice in, Placer, you're looking at somewhere between 1.5 to 3 times your specials as general damages. And if there's an opportunity for punitive damages, the attorney should be able to say what that opportunity is. And who knows what you can get for punitive damages. I've never gotten punitive damages. It's a hard thing to get. You got to prove more things, and the attorney should be able to tell you what you would need to prove to be able to qualify for punitive damages. So those are the two things that you should go into an initial client interview, a free consultation, whatever the attorney has to say. Those are two basic things that you really need to get. You really need to get to know, does your attorney know the law, and does my attorney believe that I have a good case based on the facts and the law? He needs to understand your facts and the law. If he's not willing to look at your facts and the law, you're probably not going to get a good attorney. He's also going to need to be able to give you a rough idea of what your damages are, because it makes a lot of sense for the attorney sometimes to go ahead and sue knowing that you'll win on liability, but he doesn't care if he's not on contingency. He doesn't care if you get $1 nominal damages. He's won, right? He's done a good job for you. He's won the case. And you have $1 in your pocket after spending thousands of dollars on attorney's fees. So liability and damages. Does he understand the facts and the law, and what is the basis by which you might get damages? Speaking of which, this is really for causes of action where you're seeking monetary damages. If you're only seeking injunctive relief, if you're looking for an equitable solution, then if you're looking solely for an equitable solution, then you can't really judge it by the damages part, but you could at least still ask about the liability part. Another thing that you want to really pay attention to is, if you are going in seeking monetary damages, is the attorney willing to take you on a contingency fee basis? If he's not willing to take you on contingency fee basis, if he is demanding an hourly rate or a lump sum amount, then you might want to reconsider, because most attorneys will take contingency fee cases where they don't get paid unless you get paid. Most attorneys will take those on good cases, on cases where there are significant damages and where liability is at least somewhat clear. So think about that as well. What kind of payment is the attorney expecting? Now, you may end up giving the attorney a lot more money on contingency fee basis, because you can go up to about 50% of your gross take on a settlement or a judgment going to the attorney. Whereas if you go by an hourly rate, it might be less. However, it might also be more, and there is a cost associated to money out of pocket. But find out if the attorney is willing to take it on contingency basis. Some attorneys take everything that comes through their door on contingency basis. They don't do a lot of work. They'll send out a few demand letters and not really much else. But see if they're willing to take it. It's not as good as knowing whether or not you have a good case and the attorney knows your facts and the law and your damages, but it is something to think about. It is another thing to throw in there. And really the final thing that I strongly recommend, I've worked in a couple different law firms, and every law firm has a slightly different method of handling client cases. But most firms are going to have one or more people whose names are on the firm. Most firms will. And that person is usually the person who's getting the business. People are coming in based on that name a lot of times. And that is the person who's probably going to be doing the initial client consultation. But what you want to find out is if that person is going to be active in your case. And specifically, if that person is going to be doing your pleadings and appearing at all of your hearings. In a civil matter, in a civil case, what I have found is there's two ways that most firms do it. One is where the lead attorney will appear at the trial and not much else. And where the lead attorney will not be doing the pleadings, it'll be his associates who are going to be doing the pleadings, arguing the motions, and that kind of thing. If an attorney is selling you based on his experience and that's what he's going to give you, you might want to reconsider that amount of experience. The other way is, I think, better for the client overall, because by the time a person does get to trial, the attorney who's done all the pleadings and who's been at all the motion hearings and things like that is going to have a much better grasp of the facts and the law in the case. But the other method is where a particular associate will be assigned to your case and the lead attorney won't be doing very much in it at all, period. Now, again, if they're selling you based on their experience, you might want to consider the experience of the attorney who's actually going to be representing you, not the experience of the attorney who has his name on the door. But that's, in my estimation, a better method of. It's more likely to generate a positive result if the same attorney works on your case the entire time through than if it gets passed off between attorneys. So I hope that helps. If you are looking for an attorney, good luck. There's a lot of shady attorneys out there. Find one you can trust and stick with them. Thanks for watching. Have a great day.